You with the NCA. Job cuts as a result of the coronavirus are a reality as companies retrench. Questions have been raised around the selection criteria used for retrenchments and which employees are at risk. Well, just how vulnerable are you, and to what extent are companies following Section 189 of the Labour Relations Act? Well, to answer these questions, we are joined by Michael Heats from law firm Cliff Decker Hoffmeyer. Michael, thanks very much indeed for talking to us. Before we get into the process that should be followed, presumably, there are some sectors that are more vulnerable to job losses than others, aren't they?
Thank you for having me. Yes, of course. I mean, we've all seen through the various levels of lockdown that some industries have been lucky enough to be able to continue operating, especially those who would be able to operate remotely. But there are many industries, such as hotel, leisure, restaurants, who have not been so fortunate and who've not been able to render their services during these times.
Now, those who are vulnerable want to know that standard processes have to be followed before a retrenchment process gets underway. Presumably that still stands under Section 189, doesn't it?
Yes, absolutely. Look, the national state of disaster did not suspend or alter the law in terms of retrenchments in any way. Companies that do find themselves faced with the unfortunate prospect of having to look at retrenchments are obliged to follow the processes that set out in Section 189 of the Labour Relations Act. And those processes are relatively well defined in terms of the legislation, and there's lots of case law surrounding it as to what employers can and cannot do. But the acid test really is fairness. Retrenchments are generally seen as no-fault terminations, which means that it's not due to the employee's fault that he or she may be terminated. And that's why the law really goes to task to try and ensure that the selection criteria should be objective and fair.
And it's that selection criteria that's under the spotlight. You make the point that that criteria to be used for retrenchments must be determined through consultation.
That is correct, yes. So the employer must make sure that when it selects employees for retrenchment, that it does so on an objective and a fair basis. It has long since been accepted that LIFO, last in, first out, is a selection criteria which is favoured by a lot of trade unions because it's seen to be the most objectively fair. But LIFO is not necessarily convenient or appropriate in all circumstances. And employers can get a little bit creative with their selection criteria, but at the end of the day, it does come to objective fairness. Our law is outspoken in terms of selection criteria which might have the effect of selecting certain employees who the employer does not necessarily want to retain. Unfortunately, selection criteria is not a cherry-picking exercise. You can't pick and choose who you would necessarily like to get rid of. It all depends on the fairness of the selection criteria.
Michael, it's interesting you mentioned the first in, first out rule, or last in, first out rule. But what about those who argue that, look, I've got extensive skills, I've got extensive experience in this company. To what extent does the level of your experience and skills are taken into account here?
Well, absolutely. The employer can propose that skills retention form the basis of its selection criteria. It is an issue that is up for consultation between the employer and the employees. And hopefully the parties are able to reach some form of agreement or consensus on the selection criteria, such as skills retention, because that is ultimately what an employer would like to try and retain. Ironically, that is what LIFO tries to achieve. Essentially, LIFO suggests that those employees who have the longest level of service would have the most experience, for instance, but that's not always the case. You would have some employees that would have better skills, better qualifications that might serve them to be retained over and above other employees.
Now, before I let you go, and I'm sorry to interject there, but before I let you go, what do you see as far as the CCMA is concerned? Backlogs, heavy deals?
Yes, we are seeing some backlogs from the CCMA. Unfortunately, due to the COVID situation, we are finding sporadic closures of the CCMA offices. Every now and then when a COVID case comes up, the office closes, and all of those cases scheduled for that day are postponed. So we are seeing some postponements. I must just mention that in relation to retrenchments, when 2 or more employees are retrenched, that really becomes an issue for the Labour Court. It's not so much a CCMA matter. So yes, we will be seeing some delays, both in terms of CCMA as well as Labour Court matters being heard.
All right, thanks very much indeed. Michael Heath is from the law firm Cliff Decker Hoffmeyer.